Good afternoon. We're here today to talk about disciplinary appeals by civil service employees. Government workers make up the largest segment of employees in New Jersey's workforce. Most of those employees are covered by civil service. That's all state employees, most local, county, and public authority employees. So it's a really important issue in New Jersey employment law. The idea behind the civil service system is that employment decisions are supposed to be based on merit and fitness, not cronyism, political affiliation, discrimination, nepotism. New Jersey has a history, and the civil service system tries to eliminate those nefarious motivations in hiring. Also, the New Jersey and federal constitutions require that when a government takes an action, and the employer here is the government, that the affected employees or persons get due process. In this case, that due process is the appeal process to the civil service system. So there's two types of discipline: major discipline and minor discipline. Major discipline is termination, demotion, or fine or suspension greater than 5 days. It's also can be a fine or suspension of less than 5 days if the total number of incidents of fines or suspension within a calendar year are greater than 15 days. At that point, the last suspension or fine becomes appealable. So if there's major discipline, what the employer will do is give a final notice of disciplinary action to the employee. When the employee gets that, he has 20 days to appeal to the Civil Service Commission. The notice of appeal has to be in writing. It has to be received within 20 days. And it has to state what the appeal is about. If no final notice of disciplinary action is issued by the employee has to file within a reasonable time. So when the Civil Service Commission gets an appeal of major discipline, it'll look at it. If there is a question of fact, the Civil Service Commission will transfer the matter to the Office of Administrative Law. In the Office of Administrative Law, an administrative law judge, known as an ALJ, will conduct a fact-finding hearing. During that hearing, documents will be presented, witnesses will testify, and the judge will make a decision on the facts and the evidence. The decision isn't final, though. It's a recommended decision that goes back to the Civil Service Commission. The Civil Service can either accept the recommended decision, reject it, or modify it. And that's as to guilt as well as to the penalty. Because under the concept of progressive discipline, the Civil Service Commission could reduce the penalty, saying that yes, there was guilt, but no, the penalty was too severe for the particular offense cited. The only limitation on that is they have to have a clear, almost unimpeachable reason to reject a fact finding by the administrative law judge. In minor discipline, the procedures are a little bit different. State employees have the right to go to the Civil Service Commission for minor discipline. If there's a union contract, they can elect any grievance procedures for discipline in the contract, but they still retain the right to go there, provided they waive the rights in the union contract. Local employees, on the other hand, such as state and county workers, and public authorities like housing authorities, etc., they do not have the right to appeal to the Civil Service Commission. Instead, their only remedy for relief is either the remedies that are in the employer's procedures, or to file what's known as an action in lieu of prerogative writs. That has to be filed in the Law Division of the Superior Court of New Jersey within 45 days of the action. Anyone who's facing discipline, whether it's a hearing before the employer at the Civil Service Commission, the Office of Administrative Law, or appeals from there, has the right to a representative. That representative can be an attorney, can be a union representative, or somebody else. It is strongly recommended that if your union does not provide an attorney, you get one at every stage. The Civil Service Commission can grant various forms of relief. This includes reinstatement if there was termination, reinstatement after a suspension, and back pay for the time that the employee was either wrongfully terminated or wrongfully suspended. It can order restitution of a fine. It can grant seniority if there was, say, a failure to promote for disciplinary reasons. In certain circumstances, not all, but in certain circumstances, the court has the option to award attorney's fees as well. That's kind of an overview of the civil service appeals system. We do a lot of that. We've represented many employees. We feel pretty sure we can help you. Give us a call at 973-890-0004 or fill out the contact form on this page to set up a consultation with one of our attorneys. We'd love to help you. Thanks, and have a great day.